Your Excellencies, esteemed panelists, dear ladies and gentlemen, good afternoon. At the outset, I must confess, I am not Archbishop Auza. My name is Tomasz Grysa. I am Deputy Permanent Observer of the Holy See to the United Nations, and I am very happy to welcome you to this afternoon's event in anticipation of the next Monday's 70th anniversary of the adoption of the Universal Declaration of Human Rights, which the Holy See is honored to sponsor, together with ADF International, represented here on this panel by Michael Faris, its President, CEO, and General Counsel. So I am representing Archbishop Auza, who regrets he could not be with us this afternoon, but he has very good reason. He is representing the Holy See at the 24th session of the Conference of Parties to the United Nations Framework Convention on Climate Change, this week and next in Katowice in Poland. He has asked me to deliver the following remarks in his name and to moderate this afternoon's event. So the occasion of the 70th anniversary of the Universal Declaration of Human Rights is an opportunity not only to celebrate it as one of the great achievements in the history of the United Nations, but to reaffirm its importance and recommit to promoting and defending the rights, fundamental freedoms, and responsibilities it articulates. At its adoption 70 years ago, this coming Monday, one of its principal catalysts, Eleanor Roosevelt, hoped that it would become the international Magna Carta of all men everywhere. When Pope John Paul II spoke to the General Assembly of the United Nations in 1979, he called it the fundamental document, the basic inspiration and cornerstone of the United Nations organization, and a milestone on the long and difficult path of the moral progress. It was a great triumph, he said, that had come at a tremendous cost, paid for by millions of our brothers and sisters who had suffered, sacrificed, been brutalized, and even subjected to genocide. The atrocities of 2 world wars, and especially the Holocaust, had revealed that there are some actions so wicked that no one can or will justify them, and certain fundamental values that no one will dispute. After the horrors of the first half of last century, it was obvious that human progress could not be measured only by scientific and technological advances, since even those could become weapons against the innocent. Rather, human progress had to be the integral development of persons and peoples, especially their ethical development. The Universal Declaration was a huge step forward in this process of human moral development, becoming one of the highest expressions of the human conscience of our time, as John Paul II said in his second visit to the UN in 1995. Its enduring impact, however, depends on its remaining what he called the UN's basic value, inspiring and challenging the consciences of UN members and the people of the world. Human rights are at the core of the United Nations. The preamble of the UN Charter solemnly affirms faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women and of nations large and small. But it didn't specify what those fundamental human rights were. That was left for the work of the Commission on Human Rights, which in the Universal Declaration elaborated both political and civil rights, including life, liberty, property, freedom of speech, religion and assembly, and economic, social, and cultural rights like work, education, and basic subsistence. The rights it articulated were practical, made to guide action. They flowed from the conviction that every person needs to be treated like every other human being. They were framed not only in relation to the state, but also to various mediating institutes like the family, human community, and religious groups, since human beings are persons in solidarity and fraternity rather than isolated individuals. The rights were recognized by the Declaration insofar as the framers believed they pertained to persons by the very fact that they are persons, and were not liberties merely conferred to them by ruling powers. Its 30 articles leave room for different understandings and applications according to local contexts. In fact, its genius is that it was drafted to be relevant to all peoples in a pluralistic world and has permitted diverse cultures, institutions, and legal systems to converge around a fundamental nucleus of values, transcending divisions and appealing to our shared humanity. Even though the declaration per se has no enforcement mechanism, something that was foreseen and remedied in the twin human rights covenants of 1966, many of its principles have acquired legal force through incorporation into national legal systems. As we mark this 70th anniversary, I would like to highlight 3 of its fundamental presuppositions that, because of cultural changes, are perhaps not as widely and deeply appreciated today as they were by the framers and the delegates who voted for its adoption. The first is about its universality. The Declaration attempted to formulate rights that would be valid in every age, place, and culture. It presumed that there are indeed universal human rights rooted in human nature. Human persons everywhere and at all times not only have an underlying dignity that can never be justly trampled, but also an underlying ethical substratum or conscience that can recognize the dignity in themselves and others. This universality has been challenged at times by those who have argued that the Declaration is excessively the fruit of Western ideas, or by those who think that all truth, including ethical, is relative to context, or by governments or groups who want to violate others' rights. We'll hear more about this from our first speaker, Professor Marianne Glendon. The second presupposition is with regard to objectivity. The framers thought that human nature was self-evidently the same everywhere, and that all people were capable through rational reflection of understanding certain basic truths about human nature, dignity, and rights. Removing human rights from this objective mooring in favor of subjectivistic or relativistic understandings undermines the rights themselves, permitting their universality to be denied for cultural, political, social, philosophical, or religious reasons. The framers were able to speak about human rights because they had a rich objective notion of what it means to be human. There is a modern temptation to accentuate the word rights while neglecting the even more important word human. But human rights are premised on the existence of a nature objectively shared by all members of the human race, by the very fact of their humanity. From that nature flows human dignity, which refers to the intrinsic worth of the person, no matter one's circumstances, no matter how young or old, rich or poor, strong or vulnerable, healthy or sick, wanted or undesired, economically productive or incapacitated, politically influential or insignificant. Because dignity is innate and objective, all human beings are equal in value, and human rights cannot be given or taken away by the state or any other actor. A reductive vision of the human person, on the other hand, one that treats the person as an isolated monad without a social nature or as a social being without individual dignity, opens the way to the growth of injustice, social inequality, and corruption. The third presupposition is about the unity of the rights recognized in the Universal Declaration. Some view the Declaration as a list of separate guarantees that one can choose to defend or dismiss. This undermines every right that is in the Declaration, because once some rights become optional, every right does. When Pope Benedict XVI spoke to the UN General Assembly in 2008, during the year marking the 60th anniversary of the Universal Declaration, he spoke about the importance of this unity. Today, he said, there is pressure to reinterpret the foundations of the Declaration and to compromise its inner unity so as to facilitate a move away from the protection of human dignity towards the satisfaction of simple interests, often particular interests. The declaration, he continued, was adopted as a common standard of achievement, as its preamble indicates, and cannot be applied piecemeal, according to trends or selective choices that merely run the risk of contradicting the unity of the human person and thus the indivisibility of human rights. The declaration, he was saying, is not and cannot be allowed to become a menu of rights from which one can choose according to personal, national, or international taste. As we mark the 70th anniversary of the adoption of the Universal Declaration, we can see some of the consequences of failing to uphold its universality, objectivity, and unity. Many of the provisions so clearly articulated in the UNHR continue to go unrecognized. The 2018 report of the Secretary General on the work of the organization highlights that although there has been much progress made in the advancement of human rights at the global level, challenges to the protection of human rights are a global phenomenon. The report notes that 1 in 10 children is still subjected to child labor. 1 in 3 people currently in detention is held without trial. 29% of children under 5 do not have birth registration. And there are 250 million women married under the age of 15, all directly contrary to rights recognized in the Declaration. Moreover, Article 4 states that no one shall be held in slavery or servitude, and yet tens of millions are ensnared by various forms of so-called modern slavery. Article 3 affirms that everyone has the right to life, liberty, and security of person, and yet in many places those rights are not only not respected, but their violations are even celebrated, even in the UN institutions, as you will hear from Michael Farris later. Article 18 upholds the right to freedom of thought, conscience, and religion, to change one's religion or belief, and the freedom alone or in community with others, in public or private, to manifest that religion or belief in teaching, practice, worship, and observance. Yet these rights are infringed upon, restricted, or denied, and in so many places changing one's religion or even practicing one's faith is still a death sentence or a reason to be discriminated against. Professor George will address later the importance of religious freedom. Pope Francis said in January, speaking in the Vatican to the diplomats accredited to the Holy See, "At a distance of 70 years, it is painful to see how many fundamental rights continue to be violated today," as he listed those already mentioned, as well as the violations of the rights of migrants and refugees in view of the global compacts. Perhaps the most newsworthy part of Pope Francis' remarks in January, however, involved his concern about how the language of human rights and even the human rights monitoring mechanisms are being used to advance newly claimed rights that not only do not enjoy international agreement, but in many cases reinterpret the declaration in ways contrary to the rights explicitly defended. Over the years, Pope Francis stated to the diplomats, particularly in the wake of the social upheaval of the 1960s, the interpretation of some rights has progressively changed, with the inclusion of a number of new rights that not infrequently conflict with one another. He continued, "Somewhat paradoxically, there is a risk that in the very name of human rights, we will see the rise of modern forms of ideological colonization by the stronger and the wealthier, to the detriment of the poorer and the most vulnerable, disregarding the due respect for the fundamental rights proclaimed by the Universal Declaration of Human Rights." We'll hear more on this theme from both Paolo Carrozza and Michael Farris. The point Pope Francis was making is that the human rights in general and the Universal Declaration in particular were not meant to be used as weapons to advance political, economic, military, or cultural agendas contrary to the fundamental human rights. human rights cannot be treated as open terms whose meanings different actors can change to suit their purposes. Otherwise, it will gradually eviscerate universal respect for the Declaration and human rights, leave the world worse off, and leave people far more vulnerable. This 70th anniversary is an occasion for us, with the words of the UN Charter, to reaffirm faith in fundamental human rights and in the dignity of the human person, and to commit ourselves to the promotion and defense of the rights contained in the Universal Declaration and the urgent work of ensuring human rights for all. John Paul II in 1995 said that the states that founded the United Nations in 1945 and adopted the Universal Declaration 3 years later truly lit a lamp whose light can scatter the darkness caused by tyranny, a light which can show the way to freedom, peace, and solidarity. Now is the time for us to put oil in that lamp and set it alight anew in every hall of this institution, in all international and national bodies, in universities, schools, and homes, and in each of our heads and hearts, so that the Declaration, obtained at such tremendous cost, might remain one of the highest expressions of the human conscience of our time, just like it was in the minds and hearts of the framers and peoples of the world 7 decades ago. And I thank you for your attention. I am now very happy to turn to our superb panel. Our first speaker is Her Excellency Professor Mary Ann Glendon, the learned hand professor of law at Harvard University, one of the world's foremost experts on the UDHR, and author of the acclaimed 2001 work, A World Made New, Eleanor Roosevelt and the Universal Declaration of Human Rights. Professor Glendon is the former ambassador of the United States of America to the Holy See, a former commissioner on the U.S. Commission on International Religious Freedom, and the U.S. President's Council on Bioethics. She led the delegation of the Holy See to the 4th World Conference on Women in Beijing in 1995, served for 10 years as the president of the Pontifical Academy of Social Sciences, and for 5 as a member of the Board of Supervisors of the Institute for Religious Works. In 2010, she received the Path to Peace Award, which is the highest award given by the Permanent Observer Mission of the Holy See to the UN in recognition of her commitment to the development of peace in national and international settings. She will speak to us today about how the Universal Declaration came about, the obstacles the founders overcame, its enormous significance over the last 70 years, and what today's diplomats can learn from it. Ambassador Glendon, welcome back to the United Nations. It is an honor to give you the floor.
Thank you so much for that kind introduction, and thank you for the invitation to say a few words about the history of the document that we're commemorating this week. There are many such commemorations in many places honoring the document in a number of ways, but I think here, especially in the United Nations, it's important and appropriate to honor the diplomats, the great generation of diplomats who brought this document to being. And it's not just for the sake of giving credit where credit is due, but it's a reminder, I think, to all of us that a few good men and women at crucial moments in history can and do make a difference. There's no better illustration, I think, of that point than the story of how human rights came to be included in the UN Charter in 1945. When 50 nations sent their representatives to San Francisco for the founding conference, it was a conference to found a new peace and security organization. And human rights were not high on the agenda of the major powers. In fact, it was representatives of smaller nations, and particularly the 20-member Latin American group, 20 out of 50. It was representatives of those nations who were determined to make sure that the UN Charter had a place and would reflect a serious commitment to the protection of human rights. But the major powers remained cool to the idea until May 1945, when the first photographs started to arrive from the European concentration camps. And that was what gave those who were pressing for human rights references the impetus that they needed to go forward. And by the time the conference ended, human rights references, as most of you know, were inserted into the UN Charter in 7 places, and those references included a provision for the establishment of a Human Rights Commission. I think it's fair to say that without the efforts of a determined group of diplomats, we would not have a Declaration of Human Rights to be celebrating today. So, in 1947, when the first Human Rights Commission went to work under the chairmanship of Eleanor Roosevelt, they too confronted serious obstacles. For one thing, nobody really knew whether there were any rights that were sufficiently widely shared that they had a good chance of being accepted by all then 58 members of the United Nations. For one thing, there was a deepening rift between Russia and the West. There was a crisis in Palestine, and that meant that the chances of getting a broad agreement on anything at all were formidable. They were formidably small. So that the UDHR was approved on December 10 without a single dissenting vote was something of a miracle, testimony not only to the diplomatic skills of people like Eleanor Roosevelt, Lebanon's Charles Malik, nationalist China's Peng Chong-chang, France's René Cassin, Chile's Hernan Santa Cruz. It's also testimony to the qualities of mind and character that enabled the members of that remarkable group to put aside very real personal and political differences in order to cooperate on a larger task. To be sure, there were 8 abstentions, which foreboded problems in the future. But the impressive international, I would say multinational consensus in 1948 seemed to bear out the framers' conviction that John Paul II would later state so well, that some things are just so terrible in practice that no one will openly approve them, and that some things are just so conducive to human flourishing that virtually no one will openly oppose them. But hardly anyone in 1948 imagined that the Declaration would significantly alter the moral terrain of international relations. In fact, political realists scoffed at the idea. The most famous international lawyer of the day, Hirsch Lauterpacht, opined that the Declaration was not an achievement of any great significance, and it was of negligible, I'm quoting, negligible moral authority. But the skeptics were soon proved wrong. For one thing, the Declaration immediately challenged the notion that sovereignty provided an iron shield behind which a state could mistreat its people without outside scrutiny. That alone was an enormous achievement. But it went on to touch millions of lives through the intermediary of all the instruments that were modeled upon it in the great period of constitution making that followed World War II. So new bills of rights, new constitutions, new charters many of them took the Declaration as their model. And as time went by, as we all know, parts of the Declaration became the rallying cry for the great movements that helped to bring about the demise of colonialism, the end of apartheid, and the fall of the seemingly indestructible totalitarian regimes in Eastern Europe. Today, hardly any flagrant or repeated abuse of human rights now escapes publicity. and most governments, now go to great lengths to avoid being blacklisted as notorious violators. In sum, I think one could say that Charles Malik was prescient when he speculated back in 1986 that in the long run, the Declaration might prove to be more important than the two 1966 covenants that were adopted to give it teeth. Malik said, "The morally disturbing or judging is often more effective than the legally binding." Nevertheless, the Human Rights Project has been haunted from the very beginning by a number of questions that never have been finally resolved, questions that today seem to have returned with a vengeance, questions that you will hear discussed as this panel continues. How can any rights be universal in a world of such great political and cultural diversity? How can what is to be done when fundamental rights clash with one another? What are the respective roles of society, the state, and international bodies in implementing these rights? What I find remarkable to contemplate about those questions today is that the framers of the Universal Declaration foresaw practically every obstacle that the Declaration would confront over the years. Its dependence on common understandings that would prove elusive, its buffeting from power politics, its embodiment of ideas of freedom and solidarity that are difficult to reconcile, and its vulnerability to politicization, misinterpretation, misunderstanding. So it might be of interest to inquire what the framers of the Declaration did to try to avert or mitigate some of those problems. And in my view, there are four major lessons to be learned from their wisdom. First, the number of rights that people of vastly different cultures can or will recognize as universal is relatively modest. The framers deliberately refrained from including ideas that did not have a strong claim to universality, not only to gain political support in the then United Nations, but to assure that the Declaration would have deep and long-lasting support across vastly different cultures, belief systems, and political ideologies. Second, the framers understood that universality of human rights does not mean homogeneity in their implementation. As Jacques Maritain once put it, many kinds of music could be played on the Declaration's 30 strings. The standards of the Declaration were made flexible enough to respond to different needs in terms of emphasis and implementation, but not so malleable that any right could be completely ignored or completely subordinated to another. Third, the architects of the UDHR took enormous care that it would be read not as a mere list of unrelated rights, but as an integrated document where the rights were meant to work together rather than to be pitted against each other. It would later be expressed as indivisible and interdependent. And fourth, finally, the framers took a very pragmatic approach to the implementation problem, an approach that we would today call the principle of subsidiarity, a principle that does not provide a clear path through all the dilemmas that can arise, but rather a principle that demands intelligent discernment of the appropriate level of decision-making. Ultimately, the framers believed that the best protections for freedom and dignity were in the habits and attitudes of ordinary citizens reflected in appropriate laws and institutions. So to conclude, with memories fading today about why the nations of the world decided to affirm a few basic principles as universal, it's worth remembering something about that generation. They were not utopians. They were not starry-eyed idealists. Nearly all of them had lived through not one but two world wars, economic crises, and the events of their time had shown them human beings at their worst, but also at their best. They took encouragement from the fact that while the human race is capable of gross violations of human rights, it's also capable of imagining that there are rights to violate, of articulating those rights in declarations and constitutions, of orienting their conduct toward the rights that they have recognized, and feeling the need to make excuses when their conduct falls short. To be sure, their enterprise is imperfect. They never said anything different. And to be sure, horrible violations of human dignity still occur. But thanks in great measure to those who framed the Declaration, large numbers of men and women have been inspired to do something about them. Today, Friends of Human Rights are in the process of building on the legacy of men and women who, not without reason, we call the greatest generation. 70 years from now, people not yet born will form opinions about our stewardship of their legacy. They will pass judgment one day on whether we enhanced or squandered the inheritance handed down by Eleanor Roosevelt, Charles Malik, Peng Chung-chang, René Cassin, all the large-souled men and women who strove to bring a standard of right from the ashes of terrible wrongs. How, I wonder, will we measure up? Thank you.
Thank you very much, Ambassador Glendon, for helping us to relive a little of the drama of the genesis of the Universal Declaration, for describing how it has catalyzed momentous political and cultural changes, and for sketching the valuable lessons that can be learned from it to guide not only engagement on human rights today, but so many other areas of diplomatic engagement and international policy, so that we may measure up to the challenge of its inheritance. And I wish we were able to foresee every obstacle when we negotiate our resolutions or political declarations of the UN. We'll take it as a lesson from your presentation. I would now like to turn to Professor Robert George, who is the McCormack Chair in Jurisprudence at Princeton University, where he also serves as director of the James Madison Program in American Ideals and Institutions. I am very happy to welcome several of the scholars of the James Madison Program here with us today. Professor George is the author of many books and hundreds of scholarly articles. He was chairman of the U.S. Commission on International Religious Freedom, has served as a member of the President's Council on Bioethics and the U.S. Commission on Civil Rights, and is a member of Council on Foreign Relations. He will speak to us this afternoon on the Article 18's right to religious freedom and how it is shaped and given content by the human goods it protects. Professor George, it's my honor to give you the floor.
Thank you very much, Father, and thank you to the Holy See for the kind invitation to join this very distinguished panel. To be on the panel with such eminent figures, and a very special privilege to be here with Her Excellency Ambassador Glendon, whose book, which has already been referenced, A World Made New, is the definitive work on the framing of the Universal Declaration of Human Rights. Also, thank you for welcoming our students from the James Madison Program, and thank you to Chanel Duke and to the students for coming to be here this afternoon. We live at a time when human rights is the coin of the realm. The language of human rights is the language in which much of our moral discourse takes place. And that's good because I myself am a believer in human rights and in the Universal Declaration. But I would begin with a warning issued by my beloved friend, Chief Rabbi Jonathan Sacks of the United Kingdom, who also is a believer in human rights, but who takes note of the fact that the evils of any day will be justified in the dominant terms of discourse of that day. So it is to be expected that the language of human rights, being the dominant discourse of our day, will be used to justify the evils of our day. And we must be alert to that, alert to the possible hijacking of the work of the great figures that Ambassador Glendon noted, the hijacking of that work to agendas that are quite contrary to human rights. But we mustn't let that or anything else lead us to despair of the validity of the concept of human rights. In some circles today, there is, in my view, an entirely unwarranted skepticism about the concept of rights and of human rights, or a feeling that the concept has now been hijacked and is no longer useful for talking about our problems of justice and of morality. I believe that there are human rights, and I want to say why I believe so today, looking especially at the right to religious freedom. So I think we should be champions of human rights and champions in defending the concept of human rights. Speaking of great champions of human rights, writing from a jail cell in Birmingham, Alabama, the Reverend Martin Luther King anticipated a challenge to the moral goodness of the acts of civil disobedience that landed him behind bars. He anticipated his critics asking, "How can you, Dr. King, engage in willful law-breaking when you yourself had stressed the importance of obedience to law in demanding that officials of the southern states in the United States conform to the Supreme Court's desegregation ruling in the great case of Brown against the Board of Education?" I invite you to listen to Reverend King's response to the challenge. He said, "The answer lies in the fact that there are two types of laws, just and unjust. I would be the first to advocate obeying just laws. One has not only a legal but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. I would agree with St. Augustine that an unjust law is no law at all." And King goes on, "Now, what is the difference between the two? How does one determine whether a law is just or unjust? A just law," he says, I'm continuing to quote, "is a man-made code that squares with the moral law or the law of God. An unjust law is a code that is out of harmony with the moral law. To put it in the terms of St. Thomas Aquinas, an unjust law is a human law that is not rooted in eternal and natural law. Any law that uplifts human personality is just. Any law that degrades human personality is unjust. All segregation statutes are unjust because segregation distorts the soul and damages the personality. It gives the segregator a false sense of superiority and the segregated a false sense of inferiority," unquote. So, as King says, just laws elevate and ennoble the human personality, or what in other contexts he would refer to as the human spirit. Unjust laws debase and degrade. Now, King's point about the morality or immorality of laws is a good reminder that what is true of what is sometimes called personal morality is also true of political morality. The choices and actions of political institutions at every level, those of the locality, those of the nation, those of the United Nations, like the choices and actions of individuals, can be right or wrong, morally good or morally bad, just or unjust. They can be in line with human well-being and fulfillment in all its manifold dimensions, or they can fail in any of a range of ways to respect the integral flourishing of human beings. In many cases, of the failure of laws or policies or institutions to fulfill the requirements of morality, we speak intelligibly and rightly of a violation of human rights. That's what it means to speak of a violation of human rights. This is particularly true where the failure is properly characterized as an injustice, failing to honor people's equal worth and dignity, failing to give them, or even actively to deny them, what they are due as human beings. Not in virtue of race or ethnicity or sex or height or weight or intelligence or beauty or strength, but simply in virtue of their humanity, something we all share, the weak and the strong, the white and the black, the wealthy and the poor. But contrary to the teaching of the late John Rawls, a great American political theorist, and the extraordinarily influential stream of contemporary liberal thought of which he was a leading exponent, I want to suggest this afternoon that good, the human goods, are prior to right and to rights. And let me explain what that means. My argument is that we need an understanding of the good. We need to understand the human good and human goods properly in order to understand what rights people in fact have, since there is disagreement about what our rights are. Now, to be sure, human rights, including the right to religious liberty that I want to give some focus to, are among the moral principles that demand respect from all of us, including governments and international institutions, which are morally bound not only to respect human rights, but also, to the extent possible, to protect them. Certainly that goes for the United Nations and for all of its agencies. To respect people, to respect their dignity, is to, among other things, honor their rights, including the right to religious freedom. Like all moral principles, however, human rights are shaped and given content precisely by the human goods that they protect. This is why I believe Rawls and Rawlsians are off base to suppose that we can identify rights while prescinding from questions of what constitutes the human good, what constitutes human flourishing, human well-being. Rights, like other moral principles, are intelligible as rational, action-guiding principles because they are entailments and, at some level, specifications of the integral directiveness or prescriptivity of the principles of practical reason that direct our choosing toward what is humanly fulfilling and enriching, as Dr. King would say, what is uplifting of the human spirit, and away from what is contrary to our well-being as the kind of creatures we are, constituted with the kind of nature we have, namely human beings, human persons. And so, for example, it matters to the identification and defense of the right to life in the UN Declaration, a right violated not only when the death of another is sought as one's end or as a means to one's end, but also in cases in which someone's death is foreseen and accepted unfairly as a side effect of one's action in the pursuit of an end. It matters that life, human life, is no mere instrumental good, like money or insurance policies or clothing, but is an intrinsic aspect of the human good of persons, the good of human persons, an integral dimension of our overall, all-round flourishing. And it matters to the identification and defense of the right to religious liberty that religion is yet another irreducible aspect of human well-being and fulfillment, a basic human good. But what is religion? And that question must be asked because, of course, there are many people who will immediately contest my claim of religion being a human good. They'll say, no, religion is a bad. Religion is responsible for wars and bigotry and abuse and hatred. But what do I mean by religion? Well, in its fullest and most robust sense, religion is the human person's being in right relation to the divine, the more than merely human source or sources, if there be such, of meaning and value. Now, of course, even the greatest among us in the things of the Spirit fall short of perfection in various ways. But in the ideal of perfect religion, the person would understand as comprehensively and deeply as possible the body of truths about spiritual things and would fully order his or her life and share in the life of a community of faith that is ordered in line with those truths. In the perfect good or perfect realization of the good of religion, one would achieve the relationship that the divine, say God himself, assuming for the moment the truth of monotheism, wishes us to have with him. But of course, different traditions of faith across the globe and over history have different views of what constitutes religion in its fullest and most robust sense. There are different doctrines, different scriptures, different structures of authority, different ideas about what is true in spiritual things, in spiritual matters, and what it means to be in proper relationship to the more than merely human sources of meaning and value that different traditions understand as divinity. And of course, for some, there simply are no more than merely human sources of meaning. Now, for my part, I believe that reason has a very large role to play for each of us in deciding where spiritual truth most robustly is to be found. And by reason here, I mean not only our capacity for practical reasoning and moral judgment, but also our capacities for understanding and evaluating claims of all sorts, logical, historical, scientific, and so forth. But one need not agree with me about the importance of reason in religion in order to affirm with me that there is a distinct basic human good of religion, a good that is uniquely architectonic in shaping one's pursuit of and participation in all of the other aspects of our flourishing as human beings. And that one begins to realize, and here's the important point, and participate in this human good, the good I'm calling religion, from the moment one begins the quest to understand the more than merely human sources of meaning and value, if there be such, and to live authentically by ordering one's life in line with one's best judgment of truth in religious matters. If I am right, then the existential raising of religious questions, questions of meaning and value, of ultimacy, the honest identification of answers, whatever those answers are, whether they lead you to monotheism, to some particular tradition of faith within monotheism, to polytheism, to a non-theistic faith, even to atheism. The honest identification of answers and the fulfilling of what one sincerely believes to be one's duties in light of those answers are all parts, they're the fundaments of the human good of religion, a good whose pursuit is an indispensable feature of the comprehensive flourishing of any human being. No human being is living a flourishing life if that human being does not ask the great existential questions, if that human being does not wonder, why am I here? Where are we going? Is there more than the merely visible, more than the merely material? Is there a meaning and purpose in life? But if that's true, then respect for a person's well-being, or more simply, respect for the person, demands respect for his or her flourishing as a seeker of religious truth, as a man or woman who lives in line with his or her best judgments of what is true in spiritual matters, whatever those may be, whether they're theistic, Christian, Jewish, Islamic, Buddhist, Hindu, atheist. And that in turn requires respect for his or her liberty in the religious quest, the quest to understand religious truth and to order one's life in line with it. Now, because, as Christianity, Judaism, and Islam all teach, and the same may be true of other traditions that I don't know as well, because faith of any type, including religious faith, cannot be authentic, it cannot be faith unless it is free. Respect for the person, that is to say, respect for his dignity as a free and rational creature, requires respect for liberty, religious liberty. That's why it makes sense from the point of view of reason, and not merely from the point of view of a revealed teaching of a particular faith, to understand religious freedom as what the UN Declaration, the Universal Declaration, regards it. That is a fundamental human right. And notice that that is not because we need a deal, a social contract, or a contract among nations to prevent ourselves from killing each other in a fight over religious truth. If that were the basis of the human right to religious freedom, it wouldn't actually be a human right. It would just be a deal. It's the rootedness of the right to religious freedom in the good of the spiritual quest that makes it a fundamental human right and no mere deal. Now, interestingly and tragically in times past, and even in some places today, regard for persons' spiritual well-being has functioned as the premise and motivating factor for denying religious liberty, or conceiving of it in a very cramped and restricted way. Before the Catholic Church embraced the robust conception of religious freedom that honors the civil right to give public witness and expression to sincere religious views, even when erroneous, in the document Dignitatis Humanae of the Second Vatican Council, some Catholics, including church officials, including even popes, rejected the idea of a right to religious freedom on the theory that only the truth has rights. The idea was that the state, under favoring conditions at least, should not only publicly identify itself with Catholicism as the true faith, but forbid religious advocacy or proselytizing that could lead people into religious error and apostasy. Now, I'm speaking as myself a Catholic. The mistake here was not in the premise. Religion is a great human good, and the truer the religion, the better for the fulfillment of the believer. That's true. The mistake, rather, was in the supposition made by some that the good of religion was not being advanced or participated in outside the context of the true faith, and that it could reliably be protected and advanced by placing civil restrictions enforceable by agencies of the state on the advocacy of religious ideas. In rejecting this supposition, the fathers of the Second Vatican Council did not embrace the idea that error has rights. They noticed rather that people have rights, and they have rights even when they are in error. And among those rights, integral to authentic religion is a fundamental and irreducible aspect of the human good, the religious quest, the spiritual quest, is the right to express and even advocate in line with one's sense of one's conscientious obligations what one believes to be true about spiritual matters, even if one's beliefs are in one way or another less than fully sound, and indeed even if they are false. That's why we should all, regardless of our particular faith, be advocates for the freedom of others of different faiths to practice and advocate their faith, including the rights of those who do not believe, the rights even of atheists who do not obviously share our faith, to be true to where the spiritual quest has taken them. Now, it's important to note that the Catholic Church throughout the 19th and into the 20th century was, in its official teachings, quite skeptical about concepts such as democracy and religious freedom. Today, by contrast, the Catholic Church is a champion of democracy and religious freedom. Indeed, during the pontificate of John Paul II, the Church became, in the words of Freedom House's then President Adrian Karatnicki, the world's leading force for democracy and religious freedom. Now, how did that happen? To answer that question, we need to recall that the understanding of the Catholic Church toward religious freedom had been significantly shaped by the experience of the French Revolution and the Terror. For centuries, the Catholic Church was in a certain sense mainly a European church. That shouldn't have been the case, since the whole concept of a Catholic Church means a universal church, not a European church or other local church. But the leadership of the church was dominated by Europeans. There were, in fact, 500 years of popes from one country alone, and it wasn't Poland, Father. It was Italy. Now, the ideology of the French Revolution, the ideology that eventually ends up producing French laïcité, is one in which religious freedom is associated with the idea that no religion is actually true, or all religions are equally true, or all religions are false, or that people shouldn't take religious vows because religious vows are attempts to bind one's consciences against future changes of mind, or that taking religious vows are immoral, or that taking religious vows is not a serious thing and need not be taken seriously, and, of course, the complete subservience of the church to the state. Well, if you're a leader of the Catholic Church and that's what you think religious freedom means, then you're probably going to come out against it, aren't you? And probably come out against it very strongly, and that's exactly what the leadership of the church did. Now, how did we get from there to here? Well, I believe that the American experience with religious freedom, and especially the American constitutional doctrine of religious freedom, a doctrine that is distinct from and indeed radically at odds with the French Revolutionary doctrine, revealed the possibility and put on offer an understanding that the church could robustly affirm. It showed that a better conception of religious freedom was possible, one in which none of those aspects I mentioned of French revolutionary concepts of religious freedom were part of the picture. Indeed, as the Frenchman Alexis de Tocqueville noticed as early as the 1830s when he visited the United States, religion could flourish in circumstances of freedom where you have a sound understanding of religious freedom. You don't need the state running around repressing so-called bad religions. So by 1965, when the Second Vatican Council was meeting, there was an important model of religious freedom that's shaping the ideas of Catholic thinkers across the globe. One thinker in particular, the American Jesuit John Courtney Murray, made it central to his mission to show that the American understanding and practice of religious freedom really did represent a credible alternative to French laïcité. Dignitatis Humanae reflects, among other things, his influence in embracing a full-throated, robust understanding of religious freedom, and that made it possible for the church to become a powerful force for religious freedom in the world, the same church that had been so skeptical of the concept of religious freedom a few generations before. Now, when I've assigned the document Dignitatis Humanae in courses addressing the question of religious freedom, I've always stressed to my students the importance of reading another document of the Second Vatican Council called Nostra Aetate together with it. Whether one is Catholic or not, I don't think it's possible to achieve a rich understanding of the Declaration on Religious Liberty and the developed teaching of the Catholic Church on religious freedom without considering what the Council Fathers proclaim in the Declaration on Non-Christian Religions, which is what Nostra Aetate is. In Nostra Aetate, the Fathers pay tribute to all that is true and holy, implying and then explicitly saying that there is much that is good and worthy in non-Christian faiths, including Hinduism and Buddhism, and especially, of course, Islam and Judaism. In so doing, they give recognition to the ways in which religion, even when it does not include the defining content of what the Fathers, as Catholics, believe to be religion in its fullest and most robust sense, namely the incarnation of Jesus Christ, enriches, ennobles, and fulfills the human person in the spiritual dimension of his being. This is to be honored and respected in the view of the Council Fathers because the dignity of the human being requires it. Naturally, the non-recognition of Christ as the Son of God must count for the Fathers as a falling short in the non-Christian faiths, even the Jewish faith, in which Christianity is itself rooted and which stands according to Catholic teaching in an unbroken and unbreakable covenant with God, just as the proclamation of Christ as the Son of God must count as an error in Christianity from a Jewish or Muslim point of view. But the fathers teach this does not mean that Judaism and Islam are simply false and without merit, just as neither Judaism nor Islam teaches that Christianity is simply false and without merit. On the contrary, these traditions enrich the lives of their faithful in their spiritual dimensions, thus contributing vitally to their fulfillment. Now, the Catholic Church has no monopoly on the natural law reasoning by which I'm today explicating and defending the human right to religious liberty. I use Catholicism here merely as an example of a faith that's got a strong religious view, but can affirm religious freedom for people not of the faith, and can do so on the basis of rational arguments and not simply on the basis of a revealed doctrine. And the Church has a long and deep commitment to this kind of reasoning and experience with it. And in Dignitatis Humanae, the Fathers of the Council present a natural law argument for religious freedom. Indeed, they begin presenting a natural law argument before supplementing it in the second half of the document by appealing to Revelation and to sacred Scripture. So let me ask you just to stay with me for another moment on this so that I can illustrate by the teachings of an actual faith, that happens to be the largest religious institution in the world, how religious leaders and believers, and not just statesmen concerned to craft national or international policy in circumstances of religious pluralism, can incorporate into their understanding of the basic human right to religious liberty principles and arguments available to all men and women of sincerity and goodwill by virtue of what Professor Rawls once referred to as our common human reason. Now, of course, from the point of view of any believer of any faith, the further away one gets from the truth of the faith in all its dimensions, the less fulfillment is available. But that does not mean that even a primitive and superstition-laden faith, much less the faiths of those advanced civilizations to which the Fathers refer, is utterly devoid of value, or that there is no right to religious liberty for people who practice such a faith. Nor does it mean that atheists have no right to religious freedom. On the contrary, the fundaments of respect for the good of religion require that civil authority respect, and in appropriate ways even nurture, conditions or circumstances in which people can engage in the sincere religious quest and live lives of authenticity, reflecting their best judgments as to the truth of spiritual matters. To compel an atheist to perform acts that are premised on theistic beliefs that he in good conscience cannot share is to deny to that individual the fundamental bit of the good of religion that is his, namely, living with honesty and integrity in line with his best judgments about ultimate reality. That's what a figure such as Albert Camus, who is not a theist, nevertheless does. An example of the quest for meaning and value, and of its value in someone who's not a believer. Coercing such a person to perform religious acts does him no good, since faith really must be free, or it's not faith. I mean, government can coerce the external indicia of faith. It can make you go to church or make you engage in some religious practice as an external thing. But government can't coerce what's going on in your head. It can't actually produce faith. It can only produce external behavior. Faith, if it's faith, has to be free. So trying to force faith in an atheist or anybody else is a violation of liberty that's worse than futile. Now, I'll close by saying, of course, even with so robust a defense of religious freedom is not an absolute right with no limits. Obviously, there are limits that must be respected for the sake of the common good. Even the great good of getting right with God, as best one understands God's demands, cannot justify gross evil. And gross evil, even gross injustice, can be committed by sincere people for the sake of religion. Unspeakable wrongs can be done by people sincerely trying to get right with God or the gods or their conception of ultimate reality, whatever it is. The presumption in favor of respecting liberty must, for the sake of the human good and dignity of the human person as free and rational creatures, must be powerful and broad, but it can't be unlimited. We needn't doubt the sincerity of the Aztecs in practicing human sacrifice, for example, in order to understand that such a thing is very wicked and could not possibly be permitted if we had a way of preventing it. These deep wrongs need not be tolerated in the name of religious freedom. Still, to overcome the powerful and broad presumption in favor of religious liberty, to be justified in requiring the believer to do something contrary to his faith or forbidding the believer to do something his faith requires, political authority must meet a very heavy burden. The legal test in the United States under the Religious Freedom Restoration Act is one way of capturing that presumption and burden. It's not the only way. Other nations can do it in their own terms, but it's a way of capturing a fundamental principle. And that is to justify a law that bears negatively on religious freedom, even a neutral law of general applicability. The law must be supported by what American constitutional law calls a compelling state interest and represent the least restrictive or intrusive means of protecting or serving that interest. In other words, there needs to be a very, very good reason for the imposition, and there must be no less intrusive, less restrictive means of prosecuting that very, very important end. We can debate as a matter of American constitutional law or as a matter of policy whether it is or should be up to courts or legislatures to decide when exemptions to general neutral laws should be granted for the sake of religious freedom. But whether it's courts or legislatures or who should do it, we ought to be able to agree that that should be the proper standard, that religious freedom should be respected whenever it can be consistent with the requirements of justice itself. And we should agree on that not because it's the teaching of any one of the particular faiths in the world or in our history, but because it is the fruit of the application of our common human reason. Thank you.
Thank you, Professor George, for describing for us the rational underpinnings of the right to religious freedom affirmed by Article 18 and how respect for the person demands respect for his or her flourishing as a seeker of religious truth, living in line with his or her best judgment of what is true. Many thanks also for distinguishing religious freedom from the misuse of religion to commit violence or evil to others, which is a topic that comes up frequently here in these halls. And thanks for reminding us that the meaning of Catholic means universal. Since it goes in both directions, can we call the Declaration Catholic Declaration of Human Rights?
Small c. Small c.
The third member of our panel is Michael Farris, President, CEO, and General Counsel of ADF International and Alliance Defending Freedom, which is at the forefront across the world of defending many of the freedoms contained in the UDHR when they are undermined. An expert in constitutional appellate litigation as well as in public international law, he is the author of 15 books and many scholarly and popular articles. He will speak to us on Article 3 of the Universal Declaration, which affirms that everyone has the right to life, liberty, and security of person, and more broadly on the importance of some intentional imperfections in the UDHR that are lost on some people with regard to human rights today. Mr. Farris, welcome back to the UN. The floor is yours.
Thank you, Father. Thank you, Father. Let me start by expressing my sincere thanks to the Holy See, both for hosting this event and for taking such an incredible leadership role here at the United Nations and on the issues that ADF International and I personally care about so deeply. It's an honor and privilege to be here among some of the finest scholars on international human rights law. It's been fascinating to listen to Professor Glendon's account of the history of the UDHR and to my good friend Robbie George's explication of the right of religious freedom and belief. We are gathered here on the occasion of an anniversary, the 70th anniversary of the adoption of the UDHR. Anniversaries give us the opportunity to look back, to look at where we are now, and to look where we're headed. We look back to trace what has developed and to assess progress, and we look forward to see what we need to do next and what we need to avoid. While looking back 70 years, we see a towering monument. The UDHR is a skyscraper of human aspiration toward the good, right, and beautiful. It came into existence at possibly the first moment humanity could have been ready to construct such a thing. In 1948, technology had shrunk the world, and war had humbled humanity. We were so humbled at that moment that we were willing to find common ground. It was hard work, messy. Everyone felt on their necks the first drafts of the Cold War, which is an ideological struggle like few others in history. It was a struggle over philosophy. And the question loomed, what could bridge such a divide? Well, the UDHR could, and not because it was perfect, A perfect declaration, at least from my vantage point, would have, at the very least, mentioned the source of our human rights, the dignity we have as beings made in God's image, accountable to God. Now, the UDHR mentions dignity, but it does not mention God. It does not mention God because it's the product of compromise between people coming from vastly divergent views of the world. And the key to that compromise was the agreement on all sides not to enter into the issue of where our human rights come from. This compromise, I believe, was central to the creation of the whole human rights movement. Philosophical imperialism was avoided by simply agreeing that human rights that human rights exist and they are universal, full stop. But the UDHR's imperfection shouldn't blind us to its strengths. It does not say everything that could and ideally would have been said, but it says some critically important things. And so for the first time in history, there was broad international recognition of basic human rights. On that consensus has been built the bright promise of international human rights law. Over the past 70 years, international law has developed to an extent beyond the wildest hopes of its earliest advocates. A Grotius or Pufendorf would have been overawed by what these 70 years have brought. We could spend many hours looking back, perhaps, but we must also look ahead. I've been asked to speak, as you've been told today, about Article 3 of the UDHR, so my reflections will focus primarily on the protection of life, liberty, and security of the person. As I sit here today and look forward, I'm afraid that the sky on these subjects perhaps is menacing. We are steering ourselves toward thunderclouds, and if we stay on our current course, we may soon arrive at a future point where human rights are in danger of becoming discredited, and the entire system of international human rights law may in turn be jeopardized. Distressingly, many of the actors within the international human rights system themselves are driving us toward that future. UN agencies, special rapporteurs, various committees, and some UN member states are doing something dangerous. Perhaps they believe they are trying to advance human rights as they understand them, but what they're doing is really putting the entire framework of internationally recognized human rights in jeopardy. This is manifested by the push for recognition of new and deeply troubling rights that stand in direct contradiction to the rights that are in fact recognized by the UDHR. For example, just a few weeks ago, the UN Human Rights Committee adopted General Comment number 36 on Article 6 of the International Covenant on Civil and Political Rights. Article 6 was in itself based on Article 3 of the UDHR, which establishes that every human being has the inherent right to life. In General Comment 36, the committee looked again at the right to life and suddenly discovered that the right to life, as they interpret the phrase, requires also a right to abortion and a right to euthanasia. This appears to be a classic example of turning a phrase utterly upside down. The Human Rights Committee is trying to change the most basic right, a right to fundamentally about the protecting life, into a right to take life. Thankfully, the Human Rights Committee has absolutely no authority to do any such thing, and their regrettable statement has already and will hopefully continue to be denounced by governments around the world. But as alarming as their statement is, it's representative of a broader trend. For an example, in 2014, the Committee on the Rights of the Child determined that the right to life did not apply to the unborn and asked the Holy See to amend canon law relating to abortion with a view to, quote, identifying circumstances under which access to abortion services can be permitted. Surprising. Well, not surprising. In 2016, the UN Special Rapporteur on Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment said in one of his human rights reports, in his UN reports, that banning abortion, in other words, the right to life of the unborn, constitutes a form of torture against women. I would suggest that those who are inventing supposed rights that contradict the actual textual rights recognized in the UDHR, which are in turn natural rights based in the natural law of God, they do great damage to the foundation of international human rights law. Consider how Jacques Maritain put it. Maritain supported the UDHR, and some asked how he could. He was a Catholic philosopher of natural law. How could he agree on a Declaration of Rights produced in collaboration with people who held worldviews that deeply conflicted with his own. He said, "Yes, we agree on the rights, so long as no one asks why. It was with the why that all the disagreements began." Well, the UDHR was possible because the negotiating parties agreed to settle for minimal agreement on foundational principles and to allow the details to get filled in over time. Thus, the UDHR gave us a pencil sketch, clear lines, black and white to be sure, and over the past 70 years, some in the international community have been working to carefully color between those lines, filling in the picture in a way that follows and does not violate this foundational consensus. However, those that are trying to invent new supposed rights that aren't satisfied with coloring between these established lines, they are picking up thick black pens and drawing entirely new lines over and across the old ones. They are drawing a new picture, and this new picture is directly incompatible with the original one. If their undertaking is ultimately successful, we will be left with an incoherent, contradictory framework, a framework of human rights that will amount to cultural imperialism and that countries around the world will increasingly disregard. In 2018, the nations of the world are ideologically divided, just as we were 70 years ago. But consensus is still possible on the basic human rights captured in the UDHR. There's so much left to do to protect those rights, to ensure that, to quote the preamble of the Declaration, all members of the human family enjoy them, starting with the right to life. We must not support actions that undermine the entire framework, but rather we must come together in an international community and work tirelessly for all our brothers and sisters who suffer violation of their human rights in order to secure freedom and justice for all. I thank you.
Thank you very much, Mr. Faris, for highlighting for us the practical wisdom shown by the authors of the Universal Declaration, and for candidly describing, in the context of Article 3, how some today are not only undermining the right to life, liberty, and security of person, but the very foundation of the Universal Human Rights Project. For the record, the canon law has remained unchanged.
As I suspected.
The final speaker on our panel is Dr. Paolo Carrozza, professor of law at Notre Dame Law School, where he also serves concurrently as professor of political science at the University of Notre Dame and director of the Kellogg Institute for International Studies at the University of Notre Dame. From 2006 to 2010, he was a member of the Inter-American Commission on Human Rights, the principal international body responsible for the promotion and protection of human rights in the Western Hemisphere, and served for 2 years as its president. He has written extensively in the area of human rights, their foundational principles, and the relationships between human rights, law, education, and integral human development. He will speak to us today about the need for and effectiveness of human rights accountability mechanisms in a talk entitled Institutionalizing Human Rights: Who Guards the Guardians? Professor Carrozza, I'm delighted to give you the floor.
Thank you very much, Monsignor, and to the Holy See for inviting us. It's really an honor, a privilege to be on this panel, a little bit humbling to come at the end of it after distinguished philosopher and friend, a noted advocate of human rights, and above all, a former professor of one's own. But I will do my best to do them honor. It is a little bit difficult also because my task here is to do something much more prosaic than what we've listened to so far, in a certain sense. We're used to thinking about the Universal Declaration, properly so, in terms of grand principles, high ideals, and not in terms of the ordinary stuff of processes and institutions and politics. But as a professor of law, as a professor of political science, as an actor within one of the institutions, I can't help but emphasize how much the institutions that were created, along with the creation of the human rights enterprise over the last 70 years, are absolutely indispensable to its success or to its failure. There's a paradox that the institutionalization of human rights throughout the last 7 decades has been both one of the most singular achievements of the human rights project and also presents one of the greatest challenges and problems that it faces today. Since 1948, consistently, one of the most significant features of the development and growth of human rights law as an aspiring system of positive law has been the gradual creation and accretion of authority, of institutions that are meant to give positive expression in law to the grand principles that the Universal Declaration articulates and espouses. This wasn't true at the very beginning. Of course, the Universal Declaration in its 30 articles does not by itself create any institutional mechanism for overseeing it. There was a commission created, as Professor Glendon noted, very early on, a body that had political representation by the states and was charged with ensuring that the human rights ideal infused the work of the United Nations more generally. But it was only with the creation of treaty bodies starting in the 1960s, or if one regards the regional bodies in Europe in the 1950s, but only afterwards, that institutions that are meant to ensure the accountability of states to the principles that they sign on to begin to be created. Commissions, committees, later what are known here in the United Nations as special procedures in the form of things like working groups or special rapporteurs. These gradually get associated each with their respective treaties. Each treaty creates its own accountability institution associated with it. And unlike the original political institution of the Human Rights Commission, now turned Human Rights Council, these are composed of independent experts, elected through a process by which they serve not in a representative capacity of their states. Some of them are even courts with binding legal authority, but most of them do not have the kind of formal authority that courts do. Rather, their competences are much more, let's say, interactive with the states. They may receive reports from the states and examine them, engage the states in critical dialogue about the conditions of human rights in their countries. They issue general comments, like Mr. Ferris described now, helping to foster a certain interpretive development. They receive sometimes contentious complaints by individuals. Sometimes they have investigative or fact-finding powers again. But in all of these cases, it's important to note that these commissions and committees and informal bodies, informal in the sense of not binding courts of law, don't have final interpretive authority given to them by the treaties themselves. Their role is one that is lacking of enforcement powers directly, and that is dependent on the states. Now, why? A cynic might well say, well, it's obvious. It's because the states didn't want to have to comply with the obligations they were signing on to. So they created weak institutions to go along with them. And one can't dismiss that, I'll return to it at the end of my remarks, as a possible reason. But there's a serious reason, too, and a good faith reason, that a more expansive mandate and authority to such institutions poses at least the risk of creating problems for democratic self-governance and undoing what is the proper subsidiary role of international law and institutions. Now, all of this creation of institutions over time, I should say from the outset, represents an important and in fact even essential step toward the realization of human rights in practice. In order to realize this, let us imagine for a moment a world in which the Universal Declaration was adopted, but no institutions were ever created to try to realize it in practice. What would that world look like? The norms would simply be free-floating, abstract norms. There's little possibility for arriving at any sort of common understanding of them, let alone common practices surrounding them, in part because each state would be the sole authoritative interpreter of the human rights obligations as they apply to it alone, the only guardian, precisely of norms, the whole point of which is to hold states to account for the treatment of their own citizens. It's problematic. There's no real possibility of accountability of states to one another without external institutions, because in the dynamics of international law, there's no reciprocity between states around human rights. It's not a contractual obligation. If you torture your citizens, I'll torture mine. Right? And so there's little incentive for them to hold each other to account. Even more, there's not even a fora for them to come interact. Here in the United Nations, this bears mentioning in particular what happens here every day in the work of so many of you. States and their representatives come together to interact, to debate, to persuade, to try to reach common understandings and agreements. It's a fora for them to engage civil society around the world, for raising and listening to the voices of victims. None of this would happen without institutions associated with the norms that we adopt. To put it in the terms more familiar to Professor George, the natural law calls for, and in fact needs, the institutions of positive law in order to become effective, in order to become real, in order to serve, in fact, the human goods that human rights are intended to serve. And we can see this in practice, not simply as an abstract theory. We have bodies that, despite all their limitations, spend, in fact, the great majority of their time and energy addressing grave violations of human rights. This has been true historically. The example of the body that I was called to lead, the Inter-American Commission on Human Rights, was instrumental in bringing an end to dictatorships in Latin America in its age. These bodies matter. And today, not just historically, the contemporary statistics that one sees of the cases that the institutions address undoubtedly reveal that they spend a great deal of time concerned with undisputably grave and widespread violations of human rights. Slavery, torture, arbitrary detention, extrajudicial executions, political suppression, systematic discrimination, and so on. A very high percentage of the cases simply involves the failure of domestic institutions and remedies to be effective. So all of that sounds immediately like an unqualified success, right? 70 years, we've created institutions, they're essential, and they do a lot of what they were intended to do. Well, yes and no, right? Here's the problem. There's a dark side to them as well, right? Cue the Star Wars music. International institutions of human rights have problems and limitations. Some of them are inescapable because they're inherent to the very structure of the system itself, as I'll mention. And others are more particular and specific to the current composition and practices of the bodies. In the interest of time, I'll mention 5 such problems or limitations that I've observed in practice. And I'll just note that these are great generalizations. They're not equally true of every human rights institution to the same degree. But all of them, at least to some degree, share some of these difficulties. The first is that the work of the institutions is often in tension with the very methods of universality that have been described previously in this panel. What I mean for that is this. The Universal Declaration, as we've heard, was deliberately framed through a method of arriving at practical consensus, through a language that is deliberately framed in open and flexible and inclusive terms, in order to be pluralistic, in order to accommodate the differences among the different civilizations and traditions of the human family. The positivization of human rights through the work of institutions, especially the adjudicative work of institutions, necessarily tends to make claims and choices in controversial areas. They prioritize certain understandings of human rights over others. And in doing so, their work frequently comes into a certain tension with the ideal of universality that first inspired the articulation of the norm in the first place, and thereby upsets the balance and potentially undermines the universal consensus around the basic principles. Now, that is always structurally true around any kind of adjudicative work in certain circumstances, but obviously it's even more of a problem to the extent that the bodies go to questions and issues that address the most fundamental beliefs about the destiny and nature and value of human persons, or the extent to which they implicate the delicate balance that every society has to draw between individuals and communities, or the extent to which they have to make trade-offs among rights that come into conflict with one another. The recently adopted comment on the right to life that Mr. Ferris mentioned is a prime example of that, and it is frequently visible in the extent to which the bodies create new rights or recognize significant extensions of the interpretation of old rights. One small example, a little less neuralgic than the one of abortion and euthanasia, but very illustrative, would be this. The Committee on the Rights of the Child has told states that it thinks that the convention requires the states to lower the voting age to include 16 and 17-year-olds in voting in all elections. Now, that's not an unobjectionable thing necessarily. We might all believe that that's a perfectly good thing. But does the treaty require it? And is it really the role of an international institution to be making that determination when the treaty doesn't require it? It's a case where the specification of the treaty then immediately comes into conflict with what are the proper determinations of democratic bodies and local traditions. The second problem, I'll try to be a little bit more concise about the others because they're a little bit simpler, are these. The second is this. The institutions in practice are often severely removed from the societies that are meant to be governed by the very principles that they're interpreting, where the rights are played out concretely in practice and affect people's lives. They're not interpreted and applied in the context of local realities, traditions, institutions, practices, and beliefs, but in a detached and abstract way, making them at best ineffective and at worst sometimes opening the door to what His Excellency Ausa's comments referring to Pope Francis called ideological colonization. A third problem is that this kind of detachment and abstraction from the concreteness of local reality also makes the institutions more susceptible to interest group capture. This is true in both a geopolitical dimension, where money and power of the powerful states or powerful actors internationally helps to turn human rights from a more authentic form of universality to the social-cultural projection of the powerful. But it also happens at a more micro level, one say, where the processes that go on before these institutions become not remotely representative of the breadth of the societies in which the human rights are to be acted out and realized. The processes tend to be dominated by a very small number of groups, some of them with very strong and particular ideological orientations. Fourth, the composition of the bodies themselves is very partial, almost a subculture of its own within the international community. It's very removed from domestic political processes and therefore most typically not representative of the breadth of civilizations and traditions and the rich diversity of moral and political perspectives in the human family. And finally, there's just, for all of these reasons cumulatively, very little political accountability. There's minimal supervision and minimal engagement by states. Frequently, the state's response to the work of the institutions is to ignore them. And in this way, the fundamental governance questions that are raised by issues of human rights before these institutions tend to be left in the hands of a very small and very particular and detached set of elites. Now, in an era where we are all witnessing a surge of political populism everywhere around the world, in response precisely to a sense of exclusion and lack of representation, this is a danger that we ought to be particularly attuned to, aware of the kinds of reactions it might provoke. So contrast all of that I've just described very briefly with what we all sort of intuitively know and see and understand to be, for example, the work of a judiciary in a well-functioning, healthy constitutional democracy. Right? However different constitutional systems may be, all of them function by having a judiciary that is educated in particular ways, trained in particular ways, selected very carefully, supervised in systemic ways. A judiciary that has a robust connection to the society that it is called to serve. It's reflective of it, responsive to it in particular ways. With the presence of so many from the James Madison program, one has to say it's a Madisonian conception of a judiciary, right? Whether we recognize that or not. These are bodies that adjudicate, that are embedded in constitutional and political structures that help them to remain accountable. Separation of powers, legislative work, and so forth. Elections. Rights in these contexts are adjudicated with reference to an overall common good of the communities, not piecemeal and without regard to the whole. Now, none of those things exist in the supranational systems. The closest that any of them come to including some of these broader forms of political accountability and the broad common good would probably be the European Court of Human Rights. And it is no accident that among all the institutions, it is the most effective and is seen to be the most legitimate, largely for these reasons, things that are missing from the other ones. So, is there a way forward? I'll come to a conclusion. Is there a way that we can reconcile both the value and the necessity of institutionalization for the Human Rights Project, for the good of the citizens of the world, also with a clear-eyed and realistic appreciation of their limits and perils? I think so, but only, I think, with 4 principles, at least, clearly in mind. The first principle I would call a principle of modesty, and in particular the modesty of the mandates of the institutions. Yes, it's important that we have a robust supervision of human rights, but also it's important that they be limited in their mandates. Less interested in constantly expanding and creating new rights than in securing more surely the essential core that we all agree constitute unambiguous attacks on human dignity today. Contrast that sort of modesty with the overload of cases that almost every single human rights institution faces today, unable to resolve their problems across numerous bodies, or the consistent overreach of authority that many of them exercise as putatively non-binding mechanisms. The second principle would be to recognize the subsidiarity of supranational authority. It keeps us focused on where human rights are lived and respected, and where they're violated, where they're given meaning, where they're woven into the fabric of social life as they must be. Subsidiarity gives importance to the domestic rule of law and to democracy and to the institutions of local life. And therefore, the supranational forms and institutions need to be oriented towards strengthening that local capacity, not displacing it or replacing it or doing away with it. The third principle I would call a principle of pluralism. The pluralism of traditions and inclusivity of traditions that the original framers of 1948 understood extremely well. Inclusivity at all levels within the institutions of the various traditions of law, of ethics, of religion, of language, of history, politics, and economics that the human family brings to a place like this. And fourth, a principle of accountability. In other words, even the guardians need to be guarded. Transparency is an essential part of this, and all too often lacking. But above all, accountability comes from the engagement of states with the work of the institutions. It comes from politics in the best Aristotelian sense of that word, right? Politics may not save us. It will not save us. But without politics, there is no common life and no common good to be served. So the institutions need to be a catalyst for us to political dialogue, to growth in understanding, not a distant elite to whom we delegate by default these fundamental questions of public ethics in our societies, but that provoke us to engage them together for ourselves and with each other. Without principles like these, I think it's inevitable that the institutions of human rights will increasingly be seen as irrelevant at best, and at worst, unhinged and dangerous to democratic self-governance and the common good. They will provoke resistance and reaction, which only serves, in the end, the interests of those nations and individuals, and they do exist, who do not act in good faith, who are happy to see the weakness of the institutions as a license to violate human rights in ways that serve their own self-interests. But by contrast, done with prudence and judgment and constraint, the work of the institutions in time will find that a more careful and modest and serious work will bring them more respect and legitimacy and a more consequential role in our common pursuit of human dignity, contributing to a culture of reconciliation and common understanding in this fragmented and broken world we live in. Thank you.
Thank you, Professor Carrozza, for speaking to us very clearly about the paradox of how the institutionalization of the Declaration of Human Rights has been one of the greatest achievements and also greatest challenges of the human rights system, about the essential role as well as the dark side of the institutionalization. I'm not sure if we already know who guards the guardians, but I'm confident we will have questions about what you said, as well as what our other panelists have said. Indeed, we have now some time for inputs and questions. If you would like to make a comment or ask a question of one of our panelists, I would ask you to press the call button at your place and wait until I call on you. Please keep your questions and comments brief so that we may take as many as possible, and I will take a few at a time. The floor is yours. Monsignor Hilary.
To Professor George, probably I'm the only remaining active member in this hall of the Second Vatican Council. And I remember the debate about the Dignitatis Humanae. Cardinal Meyer, and naturally the great Jesuit that you and I know, you mentioned, Kirtley Murray, they did a terrific job. But I want to clarify the point that the Declaration for Human Rights was used in that really very serious debate and long debate on that document. So that was one of the things that I wanted to clarify at the beginning. And then I would like to ask Professor George, do you think that whatever is contained in the Dignitatis Humanae, as you do know, Dignitatis Humanae and Nostra Aetate are just declarations of the Council, together with Gravissimum Educationis. But what is really, according to you, was that a static statement then made then and now? How about the development of whatever is contained there in the latest documents, especially the documents of Pope John Paul II and Pope Francis?
I will take two or three. More questions? Please. Mm-hmm.
Thank you very much. My name is Stefano Gennarini. I'm with CFAM, Center for Family and Human Rights. Thank you very much to the Holy See and ADF for putting this event together. It's really wonderful to hear so much sense coming from that podium when we hear so many silly things very often. But I had a couple of comments and questions. The first thing is, I'm not as sanguine as some of you guys about how far along the system has gone. I think in terms of just the last words from Professor Carrozza, in many ways we're already seeing powerful states ignore the multilateral system and treat it as irrelevant, including the present U.S. administration. And we also see a lot of coercion within the system and on the margins of the system. And in the negotiations, you name it, it's happening all the time. And so we're talking about, we're already at a crisis point in the institutions. And I'd like to see, in your experience, where do you think this a source for accountability, for reform, for renewal lies? And it seemed to me that, for example, with the civil rights movement, there was a real spiritual and moral battle going on politically in society more broadly that was driven by, you could call it even a spiritual awakening, if you like. Where do you see that happening for the multilateral system, and if you do so at all? And then again, once again, one of the questions that seems to be critical here is how much democratic governance itself throughout the world is threatened by a sort of you could call it the administrative state, if you like. The idea that more and more citizens are not participating, and they're delegating power, including the politicians. They're delegating power to bureaucracies, and nobody really knows how the government, what the government is doing, except the few experts in the government. If you could answer that. Thank you very much.
Thank you, Stefano. I see one young person, please.
I think I speak for all of us fellows when I say that I feel very fortunate to be here, and I want to thank all the panelists for their words today. I have a question for Professor and Ambassador Glendon. Professor, you mentioned respect for national sovereignty as an achievement of the UDHR, but I wonder, I've seen in recent history that it seems that the idea of national sovereignty, when abstracted from the human good, has seemed to be a cover in the international arena for a state treating their population in an illegitimate or immoral way, and the right to national sovereignty as a sort of guard against international intervention. So I was wondering if you could speak to that. Thank you.
Thank you very much. I think we'll start responding for the moment, then I will take some more questions. Who would like to start? Ladies first, sure.
Could I just clear up what I think is a misunderstanding? I said one of the great achievements and one of the first achievements was to establish that national sovereignty is not a shield behind which nations can mistreat their own citizens. I think there's just a misunderstanding on that one.
Yeah, let me respond to the question directed by Monsignor back there to me. If I could begin with a little anecdote. When I first began teaching right out of graduate school in Princeton in the mid-1980s, I remember the experience of standing in front of a large crowd of students with some older, many cases retired people from the community in Princeton auditing my courses. And I would begin pontificating. Am I allowed to use the word pontificate? You can. Pontificating about the great conflict between the Supreme Court and Franklin Roosevelt over the New Deal programs in the 1930s. And occasionally I could see the look on the face of one of my auditors, and the look on the face was, "Professor, you have this all wrong. I actually remember that." Because I lived during that time. So I'm having a little bit of the same experience with you, Monsignor. These are historical matters for me. I read about them in books. You were there. And I did not know what you report, and that was that the UNDHR was invoked in the debate over Dignitatis Humanae at the Second Vatican Council. So that's a very interesting and salient fact for me. Your real question for me, though, is do I think that the pontificates since the council, and I think you have in mind John Paul II, Benedict XVI, and now Pope Francis, have pushed ahead with the agenda, if I can put it that way, of the two great declarations of Nostra Aetate and Dignitatis Humanae? And to me, the evidence looks overwhelming that indeed they have. Let's lay Dignitatis Humanae aside for just a second and look at Nostra Aetate. There was no turning back not in the pontificate of John Paul II, not in the pontificate of Benedict, not now in the pontificate of Francis, from the great movement of the church in embracing the Jewish people, in honoring Judaism, in repudiating anti-Semitism. This is what Nostra Aetate is most known for. In fact, many people mistakenly believe it's the Vatican Council's declaration on the relationship of the church to the Jewish people, which is right as far as it goes, but of course the other great religions are also addressed. Look, for example, at Islam. I think that the popes since the council have looked at the very important relationship of the church with Islam and with Islamic nations and Islamic peoples through the framework that we get in Dignitatis Humanae, looking at Islam as a fellow monotheistic religion, just as we look at Judaism as a fellow monotheistic religion. Now, there is a difference because Christianity, and Catholicism in particular, understands its own faith as rooted in the faith of Israel, and that's not the same situation with Islam. But there is a recognition that there is a common ground in the worship of the one God. That's right there in the Nostra Aetate, and there has been no turning back. I mean, if you look, you won't find John Paul II or even Benedict, who's often misinterpreted on this point, for example, in the Regensburg Address, and certainly not Francis, saying, well, Islam is not really a sister monotheistic religion because Allah is not the God of Abraham, or something like that. Now, you'll find that in other places, but you will not find that in the Catholic teaching or in these pontificates. And I could tell much the same story about Dignitatis Humanae. So John Paul II goes all over the world. He is the itinerant pope. People wondered whether he was ever in Rome, because he's in the Philippines, and he's in Buenos Aires, and he's in Africa, and he's in Asia. He's all over the world, and he's preaching a gospel, if I can use that now in a metaphoric sense, though related to the gospel in the non-metaphorical sense. He's preaching a gospel of human rights and democracy, something which would have surprised Pius IX or even Leo the 13th. And that's because the concept of democracy and the concept of human rights, and in particular the concept of religious liberty, has been so deeply enriched and really transformed by the Second Vatican Council. A church that was once skeptical of those things, for very good reasons, if you think, for example, about French Revolutionary history, is no longer skeptical, but is embracing them because it's got an understanding now which is consistent with its broader conception of human dignity.
Well, thank you, Stefano Gennarini, for your very provocative comment, because it's an opportunity to clarify and expand on what are really essential points. So first, let's dig the hole deeper, as you did, right? Bureaucratization certainly can be added to the list of ills. It's no less applicable to human rights institutions as it is to the administrative state, right? Many of the institutions are dominated by bureaucratic structures in which the commissioners and so forth have almost no influence, right? And that is a problem. So, making the problem even worse, how do we get out of it? Is there a way out of it? I think so. First, though, understanding that it takes time and it's incremental. This is not the work of revolutions. It's the work of painstaking transitions, little by little, one at a time. And those can be made by individuals, as Professor Glendon's story so eloquently tells. Individuals make a difference in this. Political leaders certainly do above all, but not only. Moral leaders, civic leaders, and so forth. Where do those leaders come from? Where do those individuals come from that make the changes in the places where they work, where they live? Well, only if they come to those places with a certain education and formation. Now, I love saying this to you because you're a graduate of our law school, right? So you understand this, right? We're about forming not technical lawyers, but human beings that carry a moral purpose into the world. Education is where this has to happen, and in that kind of formation. And finally, it has to happen through the robust protection of religious freedom. Everything that Professor George mentions about the importance of religious freedom is not important simply because religious freedom is such an essential right within the canon of human rights, but because it is generative or it allows the space in which traditions can be generative of those individuals who are capable of going out into the world and bringing a witness to it of a genuine transformation.
I very much agree with you that the Human Rights Project is currently in crisis. And I think you could say, in a way, it's become a victim of its own success. There were those great advances in the 1980s and the early 1990s, and that led to, I think, the opposite of what Professor Carrazza prescribes, a lack of modesty, a kind of overweening ambition. And by trying to do too much, it's failing to do the good that was possible. And by doing too much, the proliferation of rights, which has become astonishing. Somebody counted 1,000 proposals for new rights. So I really do think that the way forward involves just getting back to basics, respecting the principle of subsidiarity, and doing the good that is possible to do.
Go ahead. You go ahead.
Michael, you
Well, I just wanted to, I think you're going to be more.
I'll just add a footnote to what I said and what Professor Glendon said as well, because in particular in this forum where there are people here who are representatives of the states, of the international community, the states have to be engaged. There is, my experience within the Organization of American States was such that there is a presumption almost that any time a state is critical of the institutions of the system, it's opposed to human rights. And there are some states who are in fact like that, right? They try to undermine the system of human rights to their own advantage. But precisely because of that, it's absolutely critical that we have states that are states of good faith, states that are committed to the human rights enterprise, who are not afraid for that very reason of being critical of the institutions, not to undo them, but sincerely to try to strengthen them. It doesn't happen enough.
If I could just say a brief word in response to your questions and comments as well. I don't believe that my country, the United States, is perfect in any respect. But I do take issue with the characterization currently, especially on the two issues that we've addressed today. The United States has taken great strides forward in the international protection of religious liberty, and the recent State Department session on international religious liberty was a remarkable achievement. Senator to me, then Governor, now Ambassador Brownback, is doing remarkable work, as have many of his predecessors in office. And so, and on the issue that I addressed, the right to life, the United States is making great strides on these two particular human rights concerns. Are there other issues the United States needs to improve on? Absolutely. Will we ever have a perfect administration? No, because we keep electing senators, because in my view, all men are senators, and we'll never elect the perfect. We'll just, we hope we improve as we go through time. But I do think it's worthy of mention of the advances of our country on those two particular fronts that we've addressed today.
Ambassador Kelly Kerry, you have the floor.
Not yet. There we go. Thank you. I just want to say, first of all, how much I appreciate the Holy See and ADF convening this forum today with this incredibly distinguished panel. As someone who went to a Jesuit law school and learned human rights law from Father Robert Drinan, one of the greats, it's almost like being back in school listening to this panel talk about these issues and the interplay between the American concept of ordered liberty and limited self-governance and the ideals that inform our political system and the human rights system that we've built up over the past 70 years on the basis of the Universal Declaration. So this has been an incredibly enriching experience, and I'm only terribly sorry that I got here so late that I missed the first bit of it, but I'm sure if it was anything like what I got here for, I probably would be overwhelmed. So I just want to say how much I appreciate that and how important this conversation is. And listening to this as somebody who's spent most of my career for the past 25 years working in international human rights as a human rights lawyer and trying to engage these systems, both from the non-governmental side and as well as now from the governmental side as a representative of a member state, you've outlined so many of the challenges that we face every day in terms of how we try to advance the system and the parts of the system that work and that do help protect rights and help improve the rights of people on the ground in countries where they're suffering, where they're being victimized, while also protecting that space for democratic self-governance and the trying to strike that balance and how we do that. And so I'm always interested to hear more thoughts from experts and practitioners such as yourselves who can help us to move that forward. And so many of the things that especially Marianne's last comment, when she said I could almost, anybody who's heard me here at the UN will know that I spend a lot of time talking about the need on human rights for us to get back to basics, to really, that's part of my standard talking points and also Ambassador Haley's about the need to get back to basics, to go back to the UDHR, to pull back a little bit and say, we are still so far from accomplishing the fundamentals that why are we even thinking about adding on lots of new stuff when we're still so far and so many people on this planet do not enjoy the blessings of liberty that we enjoy here in the United States. And so I think that that's something that we really will continue to do, and I very much appreciate the kind words from Mr. Ferris about our Ambassador for International Religious Freedom, Sam Brownback. He's somebody that we work very closely with here at USUN, and the issue of religious liberty is so fundamental to the founding of our country and to our whole idea about how we think about ordered liberty, the self-governance in this country, all of these things. It's so intrinsic to everything we do, and it's something that really guides our work here at USUN as a fundamental. So I really do appreciate that and appreciate the positive comments and the recognition of the work there. Thank you.
This is unfortunately all the time we have for questions today. I'm very sorry. And I would like to say a word of thanks to our extraordinary panel. Professor Paolo Carrozza of Notre Dame, Professor Robert George from Princeton, Ambassador Marianne Glendon from Harvard, and Mr. Michael Fares from ADF International for their powerful talks and insightful answers to your questions. I thank once again ADF International for co-sponsoring today's event and all it is doing to promote fundamental human rights across the globe. Finally, I thank each of you for coming. And as we were speaking about our shared humanity, which is the root of human rights, it reminded me one of my old nuncios, Archbishop Knox, whom Monsignor Hillary may also remember. And I will not tell you in which country it was, but when he arrived to this country, in the customs declaration, there was always question at that time about race. And each time he landed, he answered to this question writing, human. On that note, I hope that this event will prepare you for Monday's 70th anniversary and has helped you to see why John Paul II asserted that it is the inspiration and cornerstone of the United Nations organization. Thank you very much. Have a good evening. The meeting is adjourned.